Hi, I'm Chuck Marunde, exclusive buyer's agent and sunny Sequim on the beautiful Olympic Peninsula. And today I want to talk about it's a little bit of a complex subject. It involves how listing agents charge commissions and how buyer's agents earn their commissions. This is in response to questions that I've been getting from clients, and they'll often ask a question like this: well, how does this work now? If you're our buyer's agent, how do you work with us and how do you get paid? Especially after all of the national news about a multi-billion-dollar lawsuit against the National Association of Realtors and MLSs all over the country. Well, right after the $418 million settlement, I wrote a very detailed and careful article about what that lawsuit was all about and the consequences for all of us, including me and my clients. And so today I'm going to share that article with you. It'll answer some questions about commissions and how you work with a buyer's agent. Let's take a look at that article. You'll find the article by going to my website, iRealtyVirtualBrokers.com, or, easier to remember, livinginsquim.com, and go right to the menu up here at the top. And let's go to Sequim. Now, if you drop down on the left-hand side, you'll see there is a link to the Sequim real estate blog. Let's go there now. Once you're on this page, you'll see there's an introduction to the Sequim real estate blog. Just come right down to this big image right here and click on it. That will take you to the largest Sequim real estate blog, actually probably the largest real estate blog on the Olympic Peninsula and maybe in the Northwest here for any individual agent. So let's go here, and I want to, if you haven't found this blog, if you haven't been using the articles on here to do your research, understand Sequim and real estate issues in Sequim, I highly recommend it, not just because I wrote all 2,000 plus articles, but because they're specifically written for buyers. Now, let me show you. There is a search item right here. Click on that. And in this case, I'm going to look for this NAR settlement. And there it is right at the top. Now click on that. And here's the article. Now, I'm going to be very, very careful in this video and literally come down here and read the article. And there's a reason I'm reading it. It's not that I don't know the subject. I know it really well. But when I wrote this article, I wanted to make sure it was factually accurate and drawing correct legal conclusions. And so every word in here, every paragraph is very, very carefully chosen. And so that's why I want to go through here so meticulously today. For those of you who are interested in understanding how these commissions work between the listing agents and the buyer's agents now, and frankly, a lot of realtors around the country, in fact, most realtors around the country, probably would benefit by reading this article too, since it's a subject that's pretty much, you just about have to be a lawyer to understand all that happened. So let's start at the top here. The NAR settlement in 2 class action lawsuits in the amount of $418 million has shaken the foundations of the MLS systems across the U.S., as well as the way the NAR, the National Association of Realtors, and major brokerages do business. It has huge implications for both listing agents and buyer's agents, and it raises questions for sellers and buyers. This article will succinctly explain the claims in the lawsuits, the terms of the settlements, and the implications for brokers who list and sell, and for home sellers and home buyers. As always, I will get to the bottom line and explain how this will all shake out in real life, where the rubber meets the road. What are my credentials for authoring an article like this? I have 4 decades in real estate, including a long career as a real estate attorney and a continuing career as a real estate broker and owner of a boutique real estate brokerage. I'm the author of over 2,000 online articles written for home buyers, 9 real estate books written for buyers and 1 for sellers, and hundreds of educational videos for buyers. I've been living and breathing real estate since the mid-'70s, and I know how buyers and sellers think. and I know the business models and practices of all the major brokerages. I also know the legal community and lawyers. Burnett versus National Association of Realtors. The plaintiffs in the first lawsuit alleged primarily that the defendants were liable for agreeing, combining, and conspiring to impose and enforce an anti-competitive restraint that requires home sellers to pay the broker representing the buyer of their homes, and to pay an inflated amount in violation of federal antitrust law and in violation of Missouri law. On October 31st, 2023, a Kansas City jury found that the defendants had violated antitrust laws by conspiring to fix real estate commissions. The jury awarded the plaintiffs $1.78 billion in damages. Merle versus National Association of Realtors. The plaintiffs in the second of the two lawsuits claimed that the NAR and MLS organizations around the country were involved in anti-competitive practices that forced home sellers into paying buyers' agents' commissions. Plaintiffs were home sellers who listed their homes on one of 20 MLSs and filed the lawsuit against the National Association of Realtors and the 4 largest national real estate brokerages, or franchisors: Realty Holdings Corporation, Home Services of America, Inc., Remax Holdings, Inc., and Keller Williams Realty, Inc., for allegedly conspiring to require home sellers to pay the broker representing the buyer of their homes and to pay an inflated amount in violation of federal antitrust laws. Plaintiffs alleged that defendants' conspiracy centered around NAR's adoption and implementation of a mandatory rule that required all brokers to make a blanket, non-negotiable offer of buyer-broker compensation when listing a property on the MLS. This second lawsuit never got to trial. It was scheduled for early 2025 because the settlement was reached following the $1.78 billion award in the first case. Understanding the NAR settlement for $418 million. A final NAR settlement was reached with the plaintiffs on both class action lawsuits as part of a comprehensive settlement for the NAR only in the amount of $418 million. Other defendants have negotiated their own settlements with the plaintiffs in these lawsuits, which may total $500 million by the time the dust settles. Understanding the NAR settlement practical implications. As a real estate attorney and broker, I will tell you that claims in both of these class action lawsuits were totally bogus. Listing agents have not been conspiring to require sellers to pay buyers' agents a specific fee in violation of federal antitrust law. And the NAR never required listing brokers to force sellers to pay a specific fee to buyers' agents who brought them a buyer. Listing agents were obligated to include something for buyers' agents rather than put zero into the MLS. But that was common sense, not a grand conspiratorial scheme. If a seller wanted buyers' agents to show their homes, everyone understood they ought to offer them something to motivate them. And that something could have been a fraction of what the listing agent was getting paid. But in any free enterprise system, there has to be a motivation to help a seller get their home sold. Otherwise, why bother? As with far too many lawsuits, the outcome of these cases were colored by the current popular political causes, and too often guided by misrepresentations of fact and law to the jurors by plaintiffs' attorneys. Add to this the harsh reality that judges are no longer objective and fair and wise, and what do you get? Today, the big cases that are hotbeds of political passion are almost always determined in advance in the court of public opinion and later rubber-stamped in a venue that is conducive to the cultural influences. Fortunes are made, books are written, movies made, and nobodies become famous following the outcome of such cases. What really has been happening between listing agents and their sellers on the subject of paying buyers' brokers? The conversations between a listing agent and a seller for decades have gone something like this. We charge 2.5% on the listing side of the transaction, and I would suggest we include 2.5% to pay a buyer's agent for a total of 5%. The reason we suggest 2.5% for the buyer's agent is because we want to motivate buyer's agents to show your home and sell it. Does that make sense? To which every home seller I know of for decades has always said, yeah, sure. There was no pressure, no demand that they pay a buyer's agent a certain fee. In the law, it would be called force and duress to make someone sign a listing contract agreeing to pay a buyer's commission when they didn't want to. That never happened. And I go back 40 years in this business across 3 states. Discount brokers have never been kept out of the industry, and many homeowners have listed with discount brokers, while others have chosen to list their homes on a FSBO site, a for sale by owner site, or with a broker in the MLS who offered to list FSBO homes and only charge a few $100s. What the NAR settlement actually does is turn things upside down for home sellers and home buyers, since it no longer allows transparency and full disclosure on what the seller is offering a buyer's agent. One of the key elements of the settlement agreement is that listing agents can no longer include the seller's offer to buyer's agents in the MLS. In other words, prior to the settlement agreement, listing agents could include in their MLS listing a note to buyer's agents that they will be paid 1.5% or 2% or 2.5% or 3% or whatever the seller was offering to pay them. Now, the terms of the settlement agreement prohibit a listing agent from including that disclosure, which means the rule is now secrecy and lack of transparency and non-disclosure to buyers and buyer's agents. You see, listing agents can still sign a listing agreement with their home sellers in which the seller agrees to pay a split to a buyer's agent, but the listing agent now must keep that a secret from the public and from all who look at the MLS. But the loophole is that a buyer's agent is not prohibited from calling and asking the listing agent if the seller will pay a buyer's fee, and the listing agent is free to share that information. They just cannot type it in the MLS listing. This is hypocrisy of the highest order. And while lawyers structured the class action lawsuits as though they are making a Herculean effort to protect consumers, in fact, the lawsuits sought to scam consumers and hide information from them. Why would the attorneys do that? I'll tell you exactly why. Understanding the NAR settlement and who the real winners are. The claims of the plaintiffs in the lawsuits were full of specious arguments perpetrated by the only winners in the huge settlements, and we all know who those winners are. The plaintiffs' attorneys will take a huge percentage of the $418 million and the remaining $500 million. And if they had a typical agreement with their clients, they will take 40% or $392 million in total. It appears the plaintiff's attorneys will divvy up $392 million. They may get more than that, but the point is the lawyers became or will become filthy rich, but no one else in these lawsuits did. The plaintiffs in a class action are usually so numerous, their split amounts to pocket change compared to what the lawyers get. The attorneys also deduct all costs and expenses out of the plaintiff's split when they settle these things. The only winners in these class action lawsuits are the plaintiff's attorneys. Class action lawsuits are the biggest racket in the legal business, and attorneys don't just make a few million. They can make hundreds of millions. And this is exactly what's going on here. This is the reason these lawsuits were commenced, and it is the reason the claims were crafted as they were. The plaintiffs had no idea what the legal claims could or should be to convince a naive jury to award a massive judgment against the evil industry deep pockets. It is likely that the plaintiffs' attorneys actually went out and generated interest by selling the idea to a handful of plaintiffs who had nothing to lose but everything to gain. And once a handful of plaintiffs signed retainer agreements, the plaintiffs' attorneys then go to a judge and get a certification as a class action lawsuit. And now they can go out and advertise to generate as many plaintiffs as possible to participate in the class action. It's all a hoax. The attorneys create a below-the-radar marketing campaign to promote the idea of their lawsuit. And this phase of the pre-litigation often happens years before the defendants are even named. Understanding the NAR settlement, the Northwest MLS is the only MLS with guts to refuse to settle. Thank God for the Northwest MLS, which refused to settle by paying out millions to the plaintiffs' attorneys. I am proud to say I'm a member of the Northwest MLS and have been for a long time. I've written many articles praising the Northwest MLS for how they stand tall in ethics and with their rules and practices. Here's a quote from a recent Northwest MLS publication. Northwest MLS will not opt in to NAR's proposed settlement agreement. Northwest MLS is owned by its member real estate firms and not affiliated with the NAR. Northwest MLS has led the industry with initiatives that afford sellers and buyers transparency, meaningful choice, and a clear opportunity to negotiate their broker's compensation. In 2019, the Northwest MLS eliminated the requirement that a seller offer compensation to the buyer's broker. At the same time, the Northwest MLS made public any amount of compensation offered to the buyer's broker to inform buyers of any such offer. In 2022, the Northwest MLS again led the industry by providing even more transparency and flexibility for buyers, sellers, and brokers. The most notable changes include decoupling broker compensation, meaning that any compensation the seller chooses to offer the buyer broker is set and paid by the seller, not the listing broker. And any compensation offered by the seller to the buyer broker is prominently stated on the first page of the purchase and sale agreement, with an opportunity for that compensation to be negotiated by the buyer and the buyer's broker. The Northwest MLS's most recent consumer initiative was revising Washington's agency law effective January 1, 2024. The new law requires brokers to enter into a written services agreement to represent either a buyer or a seller, previously only required for sellers. All service agreements must be entered into at the outset of the parties' relationship and comprehensively address broker compensation and the details of representation. The Northwest MLS rules and forms, together with the revised agency law, provide for consumer-friendly brokerage relationships. Sellers negotiate how much to compensate the listing firm and decide whether to offer to contribute toward the buyer's broker compensation and the amount of any such offer. Buyers agree how much to pay their own brokers at the outset of their relationship and can then negotiate for the seller to help cover that cost as part of the purchase. The NAR's removal of compensation transparency from the MLS pushes consumers and brokers to make secret deals off the MLS, inviting deceptive practices, discrimination, and unfair housing. Depriving buyers of information about the transaction risks harming buyers, especially those buyers who are already disadvantaged, including first-time home buyers and members of protected classes. Prohibiting offers of compensation in the MLS also unnecessarily restrains the seller's choice and absolute right to offer compensation to a brokerage firm representing the buyer. Instead of restricting consumer choice, the Northwest MLS has seized every opportunity to enhance the quality of the real estate brokerage services in the Northwest and will continue to do so. The Northwest MLS has it exactly right when it says NAR's removal of compensation transparency from the MLS pushes consumers and brokers to make secret deals off MLS, inviting deceptive practices, discrimination, and unfair housing. Understanding the NAR settlement and what listing agents are doing now. How does all this work out in practice where the rubber meets the road? Listing agents will continue to have the kinds of conversations I played out above with their home sellers, and the sellers will agree that they want to offer to pay a buyer's agency fee equal to half of the total commission, or some similar amount. And buyer's agents will text the listing agent when they're getting ready to draft an offer for their buyers and ask how much the seller is paying to the buyer side. The listing agent will text back the amount, and it will be the exact same amount we as buyer's agents would expect to get paid, as we always have. That's it. Nothing has changed, except that the MLSs that participated in the settlement agreement, the brokerages that signed settlement agreements, and the NAR participating brokerages will now be involved in secrecy, non-disclosure, and possibly deceptive practices. Fortunately, if you're in Washington State and a member of the Northwest MLS, as I am, you don't have to be involved in any of that nonsense and chicanery, because listing agents can input the commission offered by sellers in the MLS listing detail sheet, as we always have. Understanding the NAR settlement and how it affects home buyers and home sellers. Contrary to claims of the lawsuit's attorneys and their pleadings, none of this will actually affect home buyers or home sellers. Life will go on as usual. Buyers and sellers won't notice any changes, and any promises that sellers will save commissions was all a hoax. Fair market value is fair market value. Supply and demand governs the prices in a free enterprise system. So buyers will pay fair market value, and sellers will pay commissions to list and commissions to motivate buyer's agents to bring buyers. What then was the years of litigation and posturing all about? That's easy. Follow the money. Well, there you go. That's what all that litigation was about. The bottom line, if you're working with me as your exclusive buyer's agent, you're going to find out nothing really has changed at all. The Northwest MLS is excluded from all of that nonsense and litigation and the settlement. And listing agents here are, as usual, offering to pay buyer's agents half the commission. So if you hire me as your buyer's agent, I don't charge you anything, but the seller pays my commission. Now, I have a lot of fun with that because I like to say that between my buyers and myself, we have a lot of knowledge and experience in this business. So we get to beat up on a seller and a less experienced listing agent, and yet the seller pays my commission on behalf of my buyers. It just doesn't seem fair, does it? In any event, I hope this has been an interesting video for you if you wanted to delve deeply into this subject of commissions and the NAR settlement. And I'll look forward to seeing you in the next video.